It is unusual, but it's also common for the media to argue after somebody has been convicted that they should be named, and if they are convicted and sentenced to a lengthy period of time in prison well after they turn 18, then they are named. There are, of course, considerations about the safety of somebody who is named and the safety of his family, but there is a public interest in naming the suspect in this case, and as your reporter explained, given that he's about to turn 18 next week, it's obviously perfectly sensible to name him now rather than suddenly come up with a name in less than a week's time.
Do you think the judge has been influenced by the events, and they are ongoing events, of violence which have occurred and the misinformation which has happened on social media? Do you think that has influenced the judge's decision in this case?
Judges do live in the real world, and they are aware of what has been going on in this part of the world this week. Now, it shouldn't make any difference what this young man is called. It shouldn't make any difference where he's from or what his background is.
Yes.
But certainly there has been concern about who he is.
Yep.
There has, as you've correctly reported, been a great deal of misinformation. And I'm sure that that was one of the factors that the judge took into account when deciding, as we were told by your reporter, that it was in the public interest to name this defendant now.
On many phone calls, on many of the shows this week on LBC, people have said there's a sort of the misinformation has led to a vacuum, which social media has been all too happy to fill, and in the most part for the wrong reasons. And we have seen violence erupting, not just in Southport, but obviously across the way in Hartlepool, and then further down in Whitehall. And we're hearing about other events which we're not reporting at the moment because, you know, they're just rumours at the moment about where violence could be spreading. Do you think that it's time for the authorities to look at this, that maybe they should give the name of people more immediately to fill that vacuum? Or is that just a wrong form of public pressure?
The law relates to young people under the age of 18, and the thinking behind it is very clear. That is that if you are a teenager facing charges, it may be because of your immaturity that you're brought before the court, and once you get a bit older, a bit wiser, you're in your 20s, you will look back at some minor crime you committed when you were a teenager, say, I've learnt better now, and if your name is not in the public domain, you're more likely to be rehabilitated. And that's the thinking behind the Children and Young Persons Act 1933. It's obviously been updated over the past 90 years, but nevertheless, the thinking is that young people are immature and they deserve a second chance, and if their names are all over the papers, then they're not going to have that second chance. It's very different, isn't it, if you are facing very serious charges, serious charges that could lead to a lengthy prison sentence. We all know that the sentence for murder, if somebody's convicted, is life imprisonment, and so anybody convicted of an offence like that is going to be in prison for a very long time, and so the question of rehabilitation doesn't arise. There are other public interest issues to be considered. But yes, I think it is perfectly reasonable to look at this law, look at any law, and think, do we need to lower the age from 18 to 17, 16, even lower? There are counter-arguments. I'm not sure that we should be changing the law because of one case, but if it's thought that young people mature younger these days and the public needs to know who these people are, then there is obviously something that Parliament would want to consider.